And that was the previous testimony of Michael McStay. Again, he is the brother of Joseph McStay. Joseph McStay, as well as his wife and 2 children, were brutally bludgeoned to death. Their bodies were found, Joseph McStay's partner, Chase Merritt, was charged with a crime. I have Ann Bremner with us. Ann, I want to thank you for being here. Ann is a legal analyst and a trial attorney. Thank you for taking the time to analyze what is a fascinating case for everyone who's watching.
Well, thanks for having me, and my pleasure. I mean, what a fascinating case and what interesting cross-examination just now.
Yeah, I wanted to ask you, because, here's this witness, and again, this is a trial that's going to go on for probably about 6 months. So this is the first 4 days or 3 days, and this is one of the first 4 witnesses. And basically, he's there to testify, and one of the crucial things he testifies to, is, at least what I see, is that, he went with Charles Merritt to the home when they couldn't locate the McStays. And one of the big things that the prosecutor made or said was that this witness is basically going to say that Charles Merritt refused to go in the house, and to make that somehow indicative of the fact that Charles Merritt was involved because he didn't want to go into the house. On cross-examination, we hear the witness admit that he had made prior statements where Charles Merritt had come into the house, which completely debunks the prosecution's theory.
Right, and the thing is that they should have prepared this witness, of course, and if they knew about those prior statements, which presumably they did. It's just, as you well know, is that you've elicited it first on direct examination to lessen the blow, but there it is, and it comes out as a bombshell and basically undercutting one of the biggest pieces of the prosecution's case.
Yeah, and we had spoken to Kathy Russin earlier, and I always question a lot of these murder cases when they make issues about a certain things. And one of the things I always go back to is prosecutors make an issue if a defendant cries or doesn't cry, with an expectation if they don't cry, they're guilty. I'm not sure that the prosecution theory of the fact that he didn't go into the house or did go into the house really makes a whole lot of, it doesn't matter in terms of the guilt or non-guilt of the defendant, but they wanted him there for that reason, it seemed, and they didn't get anywhere, and that's early on, so the jury's kind of getting a sense of what this case is about very early on, and it might not be going in the direction the prosecution wants.
Well, exactly. It's primacy, recency, and you want to put up your strongest witnesses to begin with as prosecutors. You have building blocks, of course, throughout your case, and then you end with a bang, hopefully, or something strong. And you're right. People react all kinds of different ways. Did he cry? Did he not cry? Did somebody act like they had remorse? Did they not act like they had remorse? When I was a prosecutor, I was always like, unless they were just cold as ice. I was pretty careful about that kind of testimony, and they should have been more careful here.
Yeah, no, I agree with you. We're going to talk more. We're going to go back in and take a further look at Michael McStay's testimony. Let's take a look. And one of the things you're hearing here, I don't know if you were able to catch it, is Michael McStay is being asked questions about whether or not Charles Merritt made statements admitting to having committed a crime in the past, of which there was eventually some back and forth between the defense and the prosecution out of the earshot of the jury, in which they raised issues as to why that should have been offered. At the end of the day, the judge said, well, the defense brought it out in their opening, and so therefore it opened the door to those questions being asked. I'm here back with Ann Bremner. I want to bring you back in. Anytime we start talking about a defendant's prior conviction, we're always concerned. I know I was concerned as a prosecution to make sure that I didn't create an appealable issue. And certainly as the defense attorney, I don't want the jury knowing anything about my client's bad acts unless the judge makes me do it. And so, a jury is impacted by hearing things about a person's prior record. Do you think that has an impact, certainly in a case like this, where he's accused of killing these individuals for financial gain?
Absolutely. Once a criminal, always a criminal. I mean, that's kind of the whole inference. And you can't bring in, as you well know, you can't bring in prior crimes unless it's a very specific circumstance, like crimes of dishonesty or false statement or punishable by greater than a year, for cross-examination, impeachment, things like that. It's pretty narrow. So, and finally, for the judge to say the defense opened the door in opening statement isn't evidence. So I don't agree that a judge should say, well, you opened the door, therefore it can come into evidence. But, that he's the judge, and the judge makes the rules, and they're final.
Yeah.
Very dangerous.
Yeah, no, a lot of, look, judges look at it different ways. Sometimes there's a question as to why the defense raised it, and if the defense raised it, then even
Right.
in opening statement, the prosecution now can comment on it. I'm not positive how that testimony in regards to the defendant admitting to committing another crime is relevant in any way to what the prosecution's theory is, other than, in a sense, getting the jury to have a lack of belief in him, even without him testifying. McStay, look, many of these witnesses are going to be testifying, and a lot of these witnesses, as you know, are going to be testifying from things that happened 9 years ago. And so a lot of these witnesses, let alone this is the brother of the deceased, a lot of these witnesses, I assume, similar to Michael McStay, are going to have some trouble remembering some of the events that happened. I know you had said that, a prosecution usually will speak to the witnesses beforehand. And one of the questions I know many jurors ask is it okay for a prosecutor to talk to their witnesses before them and to prep them in regards to what they're going to say? What's your take on that?
Well, absolutely they can. Of course, it's all discoverable. I mean, as you know well, in a prosecutor gives over everything and then some. And the defense can hold their cards pretty close to the vest. But what they have to give over also is any conversations they've had with the witness, any statements they have with the witness or anything else. So they've got to be like Caesar's wife when they question a witness. So there's nothing that could come before a jury or a judge that would basically impugn their integrity or the witness's integrity or the way that witness was, essentially prepped for trial. It's got to be all above board. You've got to tell them, as you know, tell the truth. Just tell the truth. Absolutely.
We're going to take a break in a moment. We're going to come right back, and hopefully we'll be going live into the courtroom McStay case in the next few minutes. Thank you. And welcome back. We're listening to the testimony of Michael McStay, the brother of Joseph McStay. He is testifying on cross-examination. This is prior testimony while we wait for live coverage to come through. I'm going to bring back my guest, Ann Bremner. She is a legal analyst and a trial attorney. Thank you for staying with us, Ann. The question I have, one of the things Kathy Russin had said is this is a long trial. And one of the things she noticed, because she's been in that courtroom the whole time, is she's noticing that the questions of both the prosecution and the defense are very long-winded. It's taken a long, long time to cross-examine these witnesses. And the real question I have is, does it really matter? I mean, the one issue that mattered was whether or not Chase, if we care, came in the house or didn't come in the house. I'm not sure that it really matters when it comes to the jury whether it was the 13th, the 14th, or the 15th. I'm not sure that they're getting anywhere with that. What are your thoughts?
I completely agree with cross-examination. The whole idea is to be brief, be brilliant, and be seated. That's it.
We can't always be brilliant.
No, but we can be seated.
We try.
Two out of three is not bad, right?
No, I agree, and I think the reason that it concerns me is that we start to lose the jury pretty early on, and we don't want to lose the jury too early on when we have 5 months and 28 days left to try a case. And so it does concern me that certainly with the defense, because I think they have tons and tons and tons to work with. And I think they're doing a very good job when it comes to the specifics of nailing these witnesses. But I don't want it to get too long-winded that the jury just stops listening to them.
Well, yeah, they'll just start tuning out. If you get jurors, of course, as you know, where they'll start dressing up in different colors if the lawyers even notice them, They'll be looking at the ceiling and everything else and not listening to the testimony, and you don't want it happening in the first go-around with the first few witnesses, and it could well be happening now.
Now, one of the things that's going to obviously come up is there's really not, the prosecution's theory is that the murders happened in the house. But there doesn't seem to be any forensic evidence that supports that. Yet we know that these four individuals were bludgeoned, which would expect, as the defense said in their opening statements, tons and tons and tons and tons of blood. What do you make of the prosecution's theory, and do you think the prosecution had to say that in order for them, at the end of the day, to say Charles Chase Merritt is guilty?
They probably felt that way, but I've always thought it was dangerous as a prosecutor to get wedded to a theory too soon and to never deviate from it. And with a theory like this, with a lack of blood or any kind of really evidence in the house of a brutal homicide of 4 people, that's a tough sell for a jury. I mean, the fact of the matter is the bodies were found. The bodies were found a long time later. The murder weapons were found. And so we know that they've been murdered. They were murdered someplace, and we know they left the house very quickly. They had raw eggs on the counter. I mean, all the evidence that they were just interrupted. Their lives were just interrupted and then ended. Where it happened, they don't have to prove that. As you know, the prosecutor doesn't have to prove that. So I take on that burden.
It's such a great point, and it's funny because at the end of the day, you're totally right. The jury may sit there and say, you know what, I think he's guilty, but he didn't do it there, and so therefore somehow that will not allow them to find him guilty. And I'm confused why the prosecution is so hell bent on getting the jury to believe it happened there.
Well, exactly. And think about the Scott Peterson case. Remember, they said she was killed in the bedroom. No evidence. 0 in that bedroom. Look at Casey Anthony. They basically wedded themselves to a theory that basically they didn't get into circumstantial evidence or how the baby was killed or anything else. So the jury's like, we don't know how she died, so therefore Casey Anthony's not guilty. Well, that wasn't the issue. The issue is whether or not she did it, not how the baby died. So these prosecutors get too narrow, I think, and they don't need to do that. They're taking on burdens they don't need to take on, but thereby they may undermine their own case.
Absolutely. We just found out that we are live back in the courtroom. We have a witness on the stand in the McStay case. Let's take a look. So there seems to be something going on in the courtroom. I want to just bring in my guest briefly, Ann Bremner. Here we have a witness that's testifying regarding pretty much the same thing that the witness before testified to. This is another security guard. This is the boss of the other security guard, and he's talking about the date that the vehicle was towed. I go back to what we were talking about before about boring jurors, especially with a long trial. And, look, prosecutors have that burden of proving the case beyond a reasonable doubt. And sometimes people wonder why they bring things out, and they want to cover all their bases. But, and again, I didn't hear everything this witness is testifying to, but assuming that he's going to testify to almost the identical thing that the other witness is testifying to, are we going down the wrong road as the prosecutor? Are we, is someone going to talk to them and say, let's focus, and let's get back on track? What are your thoughts?
Yeah, I mean, I think at some point, it's cumulative, of course, and there could be an objection based on that they've already had that testimony in. But, jurors, one of the things that really bugs jurors, as we all know, is they want you to be brief, be succinct, get to the point, move it along. We got it. You don't need to repeat everything to us. We're part of the courtroom, and we're listening very carefully. We're 12 sets of ears, or 14 if you've got additional alternates, etc. And this is dangerous for a prosecutor. On the other hand, circumstantial evidence is very strong. I love circumstantial evidence cases as a prosecutor because evidence doesn't lie. Witnesses can and do lie. They could be mistaken. Evidence never applied.
I love circumstantial evidence myself. Yeah. Let's go.
So
sorry to interrupt you. Yep.
No, I'm sorry. I think I interrupted you, but yeah, I love circumstantial evidence. Prosecutor puts it together piece by piece. It may take a little while, but they're doing their job.
Thank you. So we're going to head back into the courtroom and hear what this witness has to say, the security guard testifying. And we're listening to the cross-examination of another security guard that testified in regards to the movement of the vehicle that was parked near the Mexican border. We're hearing cross-examination. We're going to be bringing in Aaron Keller in a few minutes for the daily debrief. I want to just talk to Ann really quickly before we head on out. Yes, they did a quick job on questioning the prosecutor questioning this witness, so I think they were able to follow your lead in regards to that. And it seems that at the same time the cross-examination is focusing on the right points, which is poking the holes they need to even question the ability of or the credibility of this, even the smallest of witnesses, to poke holes on that circumstantial case. You agree with that?
Yeah, and I think that they're listening to us. I think they're tuned into the network.
I think so. I think that they are listening. So look, I mean, we have a long trial ahead. We hope we have you back. We want to thank you so much for being here, Anne. And in a moment, we're going to hear from Aaron Keller for the Daily Debrief. Please stay tuned and keep watching the McStay live trial here on Law&Crime. Thank you.